Hello, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation. I'd like to introduce the other two panel members. One is Pamela Hughes Ford, the legal assistant in my law office. The other is Paul Taylor, who I'll turn matters over to in just a minute. But just to say that today's topic is the WSIB's rebate to employers of billions of dollars of assessments and the advertising of their activity that went along with it. Paul?
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario, and in Ontario. Sorry, I just wanted to emphasize that because I've learned, Richard, recently. Just a side note about law is Ontario is one of the few is the only province in Canada that licenses paralegals. BC is moving that way, and Saskatchewan has an interesting limited license practice thing. It's an interesting subject that maybe one day we can talk about as another topic. At any rate, I have a specialization in workers' compensation law and human rights law as well as other areas. If you want to reach out to either Richard or myself to be part of our podcast, you can contact us through the links below. This week's topic, as Richard mentioned, is about the WSIB's rebate to employers, and specifically and as well and importantly is the advertising of that rebate. And Pamela Richards, assistant, very intelligent and knowledgeable and experienced assistant, is here. No, I'm not trying to suck up to Pamela. That's actually the truth. She's been dealing with WSIB probably more effectively than I would say most experienced lawyers and paralegals, because I can tell by when I talk to her. One of the issues that we have right now is I was curious about the WSIB's advertising of the rebate. And I think what concerned me, Richard and Pamela, was the fact that they're advertising this rebate, but it only applies to employers that are registered with the WSIB. And that means, simply put, is the WSIB would have communication methods that are free, that they don't literally have to spend, in this case, hundreds of thousands of dollars to advertise the rebate to let them know, hey, by the way, if you're a good boy and girl employer, so to speak, you get a rebate for doing a great job. And what shocked me was when I did the FOI, I learned that the WSIB in this recent round spent $540,000. That doesn't include all the other ones. And I don't know if there's a legal issue, Richard. I know it would be an ethical one, in my opinion, is in 2022 when the provincial election was on, the WSIB was advertising during that one. In that one, I did an FOI as well. And interestingly enough, the WSIB literally gave me all their invoices that they had paid, and it showed they were advertising in every major outlet in Ontario: Thunder Bay, Ottawa, Toronto, London, Windsor, North Bay, Sudbury, the Sioux. Did I miss any? Kingston, things like this. And it was very troubling to see, but they didn't tell me how much. So I can say they've spent over $1 million in advertising thus far.
So, what I wanted to do was ask Pam about what problems we're having currently with getting file access. So, to explain to our listeners, file access means the WSIB sends you electronically, for the most part, a copy of all the parts of the file in the worker's case. So you get medical reports, letters, memos in between board staff, etc. And from a lawyer's perspective, we really can't start to assist the injured worker until we get the file because we don't have all the information to plot a course to try and assist the worker. So recently we're starting to have problems with the file access. And I wanted to ask Pam because then I'm going to go back to the WSIB use of money. So Pam, what's the problem we're currently having?
Okay, so basically, since the work disruption finished in the summer of 2025, we have seen significant backlogs and delays with getting file access. So the way it works is we will send an initial letter, say that we are the rep, ask for a full copy of the file. We are told that within 4 weeks, our request will be actioned. 90%, if not more, this does not happen without us calling. Once the case manager finally refers the file to the access department, it is supposed to take 4 weeks from that point. I was told as of this week that it is now taking up to 3 months for us to get file access from the date that the case manager actually refers it, because I was told that the access department is backlogged because after the work disruption, a lot of staff within the entire WSIB system was bounced around to different departments to try and help with the backlog, which is funny to me. I say that sarcastically because during the work disruption, the WSIB was publicly making it a note that they are not backlogged and that they are still running at full capacity. But as we can see with every different department that we're facing, not only access, but even case managers, implementations are okay, but every other department, even chronic pain disability decisions, it's taking well over 2 to 3 times the amount of time that it is supposed to be taking according to the WSIB's website.
So what you're looking at is a money issue because they could hire more staff to do
Yep.
print files or get them out to this is not something you have to have any medical or adjudicative knowledge to do. So it's a money question about hiring. And secondly, the strike was mainly over pay. So rather than trying to satisfy the staff with decent pay and hire enough staff to get the job done on something that doesn't require a great deal of training, they'd rather spend the money on advertising what a great job they're doing and giving money back to employers. Paul?
Yeah, I'd just like to read a passage from a legal reference text. It's from the Canadian Encyclopedia Digest, and it talks about administrative delays in the administrative justice system. And it says, and I quote, unreasonable or undue delay in commencing or conducting administrative proceedings can be a ground for the granting of a stay or a ground for judicial review if the delay can be shown to have resulted in unfairness. And it goes on, the mere passage of time will not sustain a successful application for judicial review. The issue is prejudice to the affected person in presenting his or her case, or whether the delay is so oppressive as to amount to an abusive process. So it would be arguably, it would be a case of knowing your case to present, like procedural fairness, knowing your case and being able to effectively and fairly present it. That would be my argument. The other point I'd like to make is if it is judicial review, which would be, I assume so, then in that case, what could happen is a lawyer could bring a application for judicial review, but do it creatively and I actually read somewhere, and I think it was in BC, or maybe it was Ontario, where a judge had granted a class action application for judicial review. And the judge's reasoning was, well, why not? It's the same as a civil application where if you're going to sue somebody, if it's one person, it's regular. If it's a group, it's a class action. And I found that very interesting. So if there is a group of individuals, like maybe hundreds or thousands of injured workers that are feeling this delay, and it's not just a inconvenience, as the judge may say, or the court, and it's becoming to the point. I think the thing that's missed, I know it's not missed on you, Pamela Richard, is I think the thing that's missed by the board of directors at the WSIB, or the president, and refusing to allocate the resources because we know they have the money and the resources. They're just choosing not to. But I think the thing that's being missed is if you're an injured worker and you make, say, 70,000 a year or whatever, the average worker I think is 50, 70 or whatever, and then all of a sudden you're seriously injured and the board says no and they deny your claim. Now your life comes to an abrupt stop. What I was taught in high school, which is completely wrong nowadays, is you should have the equivalent of 3 months' salary in your bank account for emergencies. And you'll blow through that very quickly, waiting for an appeal. And then you start to, in typical fashion, rack up your credit cards and credit, and then your life falls apart very quickly. What did you say, Pamela, the wait time was? 6 months? Long?
Well, okay, so it used to be 4 weeks to get file access from when the case manager actually did the referral. So not from the date of the letter, but when the case manager does the referral. Now we're looking at up to 3 months. So as of this week, they are working on access requests that were sent by a case manager to the access department from the beginning of November. And we're in January. So it's going to take up to 3 months.
So the average person would have, if they went with the old standard of 3 months savings, have blown through their savings surviving. And what angers me is the Minister of Labor or the WSIB will say, well, just tell them to go on welfare. First of all, I have a big personal issue with that. Injured workers should not be using social assistance at all. I'm not blaming them. I'm saying they shouldn't have to. That workers' compensation is like private insurance. Like, for example, car accidents or slip and falls. If you've been injured, you shouldn't have to, according to the philosophy of the system going back to 1915, you shouldn't have to rely on taxpayer funded programs. Why should I or you as taxpayers have to fund the WSIB because they're being too slow? And that's a legitimate argument. So injured workers shouldn't have to be waiting. There's two options here. One, move the system to the point where there is no delay, which will honestly be impossible. The other is to start providing interim benefits to these cases. And I think that could be made as a legal argument in court, where in the Judicial Review Act, I believe, and Richard, you can correct me if I'm wrong, that you can, when you make an application, actually make a request for interim benefits. Now, I don't think any judge would be willing to set that precedent, but you never know, especially if you're making it on human rights and compassion grounds. Like the board is sitting on billions in surpluses, and you're sitting on the possibility of being evicted next week. Somehow I don't see the rationale in that.
The There is a group which I just looked up to get their name right, Tribunal Watch Ontario, and they report to us about every 4 or 5 weeks. It's a bunch of lawyers and paralegals who watch what's going on in the tribunals. And the Human Rights Tribunal is like years behind in doing decision making. And the recent article they sent us is that half the decisions of Human Rights Tribunal are dismissed because the people who are doing the applications have given up and aren't answering the correspondence back from the tribunal years later.
It's actually it was sometime like 6 months ago last year sometime where Tribunal Watch did an excellent research study on HRTO's decisions and they found that 93% of applications were dismissed or whatever, and there was the two reasons they explained. One was through summary proceedings, which in the big courts you call summary dismissal motions, where that's where the HRTO will go, I don't think you have a case, and then put the onus on the applicant to prove, in my opinion, beyond a reasonable doubt, you have a case. And to be quite honest, I'm actually noticing this in small claims court too. This concerns me as, I guess you'd say, a person in the legal system, that I'm getting this feeling that there's some push, and I will honestly say from the political side, on this justice system to clear the backlog by just dismissing everything. The HRTO was the first we seen, and it was very disturbing. There were some decisions I seen where if an injured worker had filed an application against the WSIB, not the case manager, never file anything against the staff, always file it against the employer, being the board, tribunal, whoever. At any rate, in that one, the HRTO dismissed it. And I'm like, wait, no. The board itself has no immunity at all. It says it right in their act, section 179, sub 3. The board has no immunity. The staff have limited immunity. But I'm not going to get into that. I'm just talking about that issue. And it's just troubling in the sense of it draws me back, Richard, to that survey that the Law Society did on Canadians and their perception of the justice system. And I think we discussed it before. And one of the points that if that study was going to be done again is I would like them to ask the questions and kind of dig deeper into their feelings in the sense of, are you talking about civil court, divisional court, civil court, the higher courts, appellate courts, things? Are you talking about administrative law and what areas of administrative law? And I think you'll probably find, guessing here, in my opinion, personal opinion, is that the bulk of those concerns lie with the administrative justice system, with delays, and sadly with access to justice. And I think it was around 93 or 94% of Canadians were very concerned about delays and access to justice. And if anybody's curious about that study, you can go to the website hourstoprotect.ca and they have the research study there.
The there's a possibility that one could go on a class action or judicial review for the 3 or 4 clients we currently have who are going to have to wait 3 months to get their file. And presumably by the time you waltzed into court, which means you have to get the paperwork done, you have to get a date. The WSIB has to approve the date so their lawyers can be present and have opportunity to prepare their case. The problem is by the time you got to court, the 3 months would have elapsed and the file would have gone out. Presumably, the lawyers for the WSIB would say, well, we ran into some difficulties. There were holidays, there was a strike, but we've got the situation under control. Things are improving, and we'll be able to get the file access out in 5 or 6 weeks, which is historically what they would do. Uh, I think the problem from our perspective is that you need to spend tens of thousands of dollars worth of time to try and fight back against the WSIB on one of many hundreds of issues.
Yes, you hit it right on the head right there. Like I would say, first of all, as far as urgency, Richard, and this was my argument I made with the lawyers and the divisional court judges and the Court of Appeal was they're wrong that an application for judicial review can only be done to the divisional court. And I'm going to make this argument at the Court of Appeal because respectfully, and I do genuinely say this as respectfully, the Chief Justice was wrong when he said all applications for judicial review are to go to the divisional court. The law actually says, Section 6 sub 2, I'm quoting it, an application for judicial review may be made to the Superior Court of Justice with leave of the judge thereof, which may be granted at a hearing of the application, and I'm reading it, where it is made to appear to the judge that the case is one of urgency. So it'd be like brought, as you know, like a motion, which means you could theoretically, if you had it together, have it heard next week. So time in that isn't the issue. Where the issue lies, what you just hit on the head, is money. Is injured workers don't have that kind of money to pay the lawyers that, and they'll complain and go, well, they're so expensive. Yeah, because there's a reason for it, which is the years of education. Law school isn't cheap. Geez, the Law Society's licensing fees are expensive. I mean, it's a broader thing that people just don't understand what it costs. My concern is that those legal costs should be covered by the WSIB prior to you even bringing the application. And a good example of that is the refugees in Canada. I'm not saying no or nothing. I'm not. I'm comparing systems, that's all. I agree that system should work and stay. It's fine. I don't have an issue. What I'm saying is if a person who's a refugee has a concern with Immigration Canada, administrative justice, and they want to bring a judicial review to, in that case, the federal court, they can, no problem, and their legal costs are covered. And I agree with that because that falls under the umbrella of access to justice, which our country, our government, and the courts, including the Chief Justice, Wagner, endorses and supports. What I don't understand is when it comes to injured workers, they're not doing that, even though the law says it's to be done.
I wonder if we're looking at sort of a political cultural question. So let's take something relatively simple and not administrative, which is the age 65 limit to WSIB benefits for all injured workers. So the Minister of Labor, I think, has said that he's looking at this issue. which is like, for us, it's a big accomplishment that at least it's in their radar. I pressed this matter to court 13 years ago. I was told only 9% of workers work past 65. It's now close to 30% working past 65 to age 70. And the government could recognize this, pass some regulations saying that if the worker can show some evidence that they would have kept working, they can get entitlement to age 70. That's what's done in BC and Alberta. And it might cost a few $1 billion, which the WSIB doesn't have to say to employers, could you please give us a few $1 billion more? They can just take it out of their surplus of funding. But the question is, why not? Why isn't this not sort of a hot topic for the government itself, given that Injured Workers Consultants has been bringing this forward hot and heavy for the last few months? And I think it is the political culture is injured workers are like the scum of the earth. They're getting more than they deserve. A lot of them aren't legitimate. And why the best thing to do is pay less, not more.
I think the sentiments of this current government, being conservative, as Doug Ford, it really comes like it really rings home true, the statement when he said to the person in the gallery, get a job. He didn't know the guy was unemployed. He assumed he was. He's painting everybody with the same brush and saying, you're all unemployed, lazy bums. And I do find it ironic when I look at his track record for work that in the past year he's worked, what was it, 54 days or something? It was, I seen it in one of the posts and I was just like, well, there you go. He's too busy selling himself as a politician than he is to actually doing the work of a politician. And I think, in my opinion, that's why, and this is where I think maybe we differ, is that's why I think currently advocating in the political realm is useless. Doug Ford had promised injured workers during the 2022 election he would raise benefits to 90%. He didn't, because anything that will cost employers, he won't do. If you look at all these working for workers bills that the government has done, zero have cost employers. In fact, recently he said employers are required to provide the clear defibrillators, right? That save lives, which is great. But that all the employers are getting that free from the WSIB monies. You know, my question to the WSIB and the legal department is this question is if it's proven all your conduct that you've done, giving these rebates and doing the defibrillators and all this stuff, like that's one thing. But what if your conduct, the policies, these covert policies, like the one you caught very brilliantly, and I'm not sucking up to you, it's the way you presented to the court, it was brilliant, was the pre-existing condition thing. You weren't suing for benefits or damages, you were suing for the legal fees. And that's why I say it was brilliant. But what if it's proven more cases? Like we're in discussions and we're talking about the unemployability and these other factors that they become huge, meaning billions. And the board's sitting there going, and I know what they will do. They will sit there and say to the judge, well, Your Honor, they will do the argument made, what was it, over 300 years ago to a judge when slave owners were saying, you can't free the slaves in England because if you do, we will fall into economic chaos. And to that, the judge said, though the heavens will fall, justice shall be done. Meaning, judges can't look at what could happen in making their decisions. They have to base their decisions on evidence, facts, and law. And I'm finding sometimes, and maybe it's just me, that judges are kind of slipping the wrong way. Not all, I'm just saying it's a perception. And that's a huge issue as well. As there's another, I love these dictums or doctrines, and one is what's it? Justice must not only be done, it must be seen to be done. And that was in England in 1924. Chief Justice issued it. That was a cool one. I like that one because oftentimes when you're making arguments, I find judges They do rightfully attack your case. Like that's why I sometimes enjoy sitting at the Court of Appeal and you watch the judge asking the questions. It's always one usually. And when they're going after one lawyer, one side all the time, you're like, oh, he's done. He's lost, right? And it's usually the way. I noticed that when David Curtis and the other two injured workers were at the Court of Appeal for their for the provincial offenses where the WSIB was prosecuting injured workers. And I'll never forget the phrase of the judge. I was surprised. I really wasn't that. Where the judge said, isn't it enough you took their benefits away? Now you want to throw them in jail? And I thought that was a very powerful statement. But as far as I'm concerned, Richard, it didn't go far enough in two ways. One, when I read the transcript of David's file, it really bothered me as a paralegal, like as part of the legal system. The judge literally said, I'm going to ignore all this medical evidence and I'm just going to listen to this person, a medical lay person, as to the medical opinion of this person. I was like, what? And it went all the way to the Court of Appeal, and they said, well, the board didn't meet its mens rea. It was more than that. But, you know, I digress. The
Well,
other
let me interrupt you for a minute.
point,
Going to court and making an argument that the WSIB is not complying with either the statute or reasonableness is done before, and sometimes it works, sometimes it doesn't. But there's a clear path. It's just a matter of spending the resources to do it. On the political side, though, we invited all our injured workers to come out for Injured Worker Day, which I think is what, June the 1st?
Hmm.
yes.
So we sent out invitations and then we actually did phone ups. We phoned the injured workers saying, can you come out? And 95% of them gave an excuse as to why they couldn't show up. So here it is. They're being treated improperly by the WSIB, which is part political, as there's political control in part of the WSIB. And they didn't make it out to Queen's Park. It wasn't like we were asking them to go to the North Pole. They just had to get to the city of Toronto. They had numerous excuses and or just didn't show up altogether. So I think it goes beyond not enough cases going to court. It goes beyond Doug Ford showing what a great job he's doing to the general public by saying I'm giving money back to employers. It goes to sort of this general cultural thing, which is we're not giving a hard enough push for justice throughout the political lobbying.
Richard, do you remember? Oh, God, it was a few years ago when Doug Ford was in, it was around 2018, 2019. The paramedics across Ontario all converged on Queen's Park and they protested because he was going to do something where basically he was going to cut services. And they came together as a group, and I believe it was close to 5 to 7,000 attended. I was there. It was really cool. It was fun. It was an enjoyable, safe, peaceful protest. And it was amazing. It was well organized, well resourced. And when I look at that compared to injured workers, but here's the difference. And then you look at when unions like the OFL and them, when they do their thing, they come out en masse. And I think, and I could be wrong, but I'm just saying this is one thing that I've been advocating for on defense of injured workers, not in general, not all of them. But I think one of the big reasons is when I sat at the Court of Appeal hearing David's case, a kind of, what would you call it, the hair on the back of my neck stood up. I got a little nervous. I'm not going to lie, I was scared because I'm an injured worker and they want to throw these injured workers in jail. Then I started researching the WSIB's convictions and I found four injured workers who received not 6 months or 30 days, a year in jail. Like when I see how the judges in the courts, in the lower court, the provincial offenses court and trials view these cases, not all of them, some, where they're basically deciding the case before the evidence, judicial bias. It really scares the hell out of me as an individual that I'm like reluctant to go, but of my age and of my mentality, I don't care. But with that said, I do give credence to those that are literally afraid. See, the difference between the two I noticed was the paramedics had a strong support network, the union, to fight and help them. An individual injured worker, unless they have you or me or some other, they have nothing. The rare ones where they're unionized, which is good. And I think that's something that's generally missed. I'm not saying, well, we're not, I'm saying if we can deal with that issue, I don't know how, then I think you'll start seeing more coming out. I go back to the 1982, what first started the Injured Worker Day. And on that day, there was what, 4,000, 3,000 injured workers showed up. So, what's the difference between that day and today? And I think genuinely, it's the change in attitude of the government and the WSIB on injured workers. They're not,
Okay,
There,
so we're going to have to leave
yeah,
this political, legal, and cultural
that's a
discussion.
good one.
Come back to it again sometime. And for our audience, if you have some comments from your perspective, don't hesitate to send us
Let us
email
know
or
what you think, why injured workers aren't coming out to the big protests and that and trying to make change.
right,
Also, one other thing, if people want to complain, complain to your government, contact your MPP, contact Doug Ford directly, complain about what is happening. I feel like we can make noise if we have enough people that will get together and not be fearful of what could happen with their benefits, for sure.
right. Okay, thanks very much, everybody, and see you next week.
Thanks, everyone.
Thank you. Take care.